Rule 1 for granting time allowed, but instead granting time allowed, my suit itself has been dismissed, my lord, for want of evidence.
कितनी बार आप मौका ले चुके थे एविडेंस पेश करने के लिए?
my lord, मौका तो ज्यादा बार ले
ये आया है
जी
तत्पश्चात पुनः
जी
पढ़िए पेज 13 पर।
पेज 13
प्रकरण
पर
के अवलोकन से दावे में दिनांक को वाद प्रश्न की विरचना की गई थी।
जी
उपरांत वादी साक्ष्य हेतु 13, 8, 6, 1, 2, 3, 4, 5, 6, 7
जी
ठीक है।
जी अंकित की गई साक्ष्य
पुनः वादी साक्ष्य हेतु
जी
ये 7
जी
इसी बीच को प्रकरण अंतर्वर्ती प्रस्तुत किया गया जिसका किया गया। तत्पश्चात पुनः
जी
8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18 से आज दिनांक तक प्रकरण को नियत
जी
किया गया। आदेश
बीच में दूसरी एप्लीकेशन वगैरह भी थी
हुई होंगी, ठीक
जी
है।
जी
विलंब कारित किया जा रहा है। वादी अधिवक्ता को 500 रुपए के परिव्यय पर अंतिम अवसर प्रदान किया जाता है
जी
22/8 को, ठीक है ना।
जी
उसके बाद
आज यहाँ से पढ़ूं मैं?
आज वादी अधिवक्ता द्वारा
आवेदन पत्र प्रस्तुत कर यह बताया गया कि वादी प्रमुख सैनिक ड्यूटी में है एवं वादी वसंत विधि विकसित हो गया है, जबकि न्यायालय के समक्ष स्वयं वादी साक्षी सस्त मस्तिष्क से अपनी साक्ष्य अंकित की गई है। वादी अधिवक्ता का यह कहना है कि वसंत विधि विकसित हो जाने के कारण वह अन्य साक्षियों को न्यायालय में उपस्थित नहीं करा पाया। उक्त संबंध में वादी या उसके अधिकृत अधिवक्ता द्वारा विक्षिप्तता के संबंध में चिकित्सीय प्रमाण पत्र प्रस्तुत नहीं किया गया। वादी की ओर से उक्त समस्त दिनांकों को वादी
कुछ गलत नहीं है इस ऑर्डर में
साहब मतलब इसमें हमारा पूरा दावा ही खारिज कर दिया उन्होंने।
दावा खारिज नहीं किया, पढ़ लीजिए जरा।
जी साक्ष्य के अभाव में इस प्रकरण की कार्यवाही इसी स्तर पर समाप्त की जाती है।
हाँ तो जितना इतना ठीक कर देते हैं। देखिएगा
जी
आपने एक की तो एविडेंस करा दी ना,
दो वादियों
हाँ,
की
जिनकी विटनेस हो गई है बस उनकी विटनेस पे डिसाइड करेंगे, ये लिख देते हैं।
मतलब उसमें मेडिकल सर्टिफिकेट भी दिया
कहाँ है वो मेडिकल सर्टिफिकेट? पेज नंबर
इसके यहाँ फाइल नहीं है साहब,
तो
लेकिन
फिर उसको नहीं माना जाएगा, सॉरी।
नहीं वहाँ
I
फाइल
will not grant you any opportunity to lead evidence. I will only say a trial court will decide the suit on its own merits on the basis of the evidence of the plaintiffs if defendants after affording an opportunity to the defendants to lead evidence. That's all. Nothing beyond it. Sorry. आप लोगों की इस तरीके का बर्ताव बिल्कुल बर्दाश्त नहीं किया जाएगा। 20-20 बार आपको टाइम थोड़ा ना दिया जाएगा, और आपको टाइम ही चाहिए तो 1 लाख रुपए की कॉस्ट पे टाइम दे देता हूँ।
सफिशिएंट कॉज वाज शोन।
Sufficient cause is not made out. Medical certificate लिखिएगा, श्री कमलेश द्विवेदी, learned counsel for the petitioner. This miscellaneous petition under Article 227 of the Constitution of India is filed by the plaintiff being, आप लोगों को इतना भी लिखने में तकलीफ होती है टाइटल में कि ये प्लेंटिफ है कि डिफेंडेंट है। हाईकोर्ट रूल्स का उल्लंघन करते हैं आप लोग।
आई एम सॉरी सर।
By the plaintiff, full stop. Petitioner has not even bothered to mention in the cause title that whether the petitioner is a plaintiff or defendant before the trial court,
आई एम सॉरी,
which reflects complicity on the part of the counsel and not complying with the orders, rules of the High Court. Next,
आई एम सॉरी फॉर
petitioner's
दैट।
grievance is that petitioner is aggrieved of order dated 22/8/2022 passed by learned First Civil Judge Junior Division Majoli, First Additional Judge to First Civil Judge Junior Division Majoli, District CD, in civil suit number 55A/2019, not only closing the right of the plaintiff to lead evidence but dismissing the suit at that stage. Full stop. Next paragraph. Shri Dwivedi has put forth two submissions. Firstly, right to lead evidence should not have been closed for the reasons mentioned in the application. Secondly, that suit should have been not dismissed but should have been decided after closing the right of the plaintiff to lead evidence by giving an opportunity to the defendant to lead evidence if they so desired and deciding the issues so framed by the trial court. Next paragraph. As far as first submission is concerned, impugned order reveals that case was fixed for evidence after framing of issues on 5/8/2021. Full stop. Case was fixed for evidence on 13/8/21, 6/9/21, 9/9/21, 14/9/21, 28/9/21, 1/10/21. Full stop. Thus, after availing 6 opportunities, plaintiff Pramod Dwivedi had led his evidence on 27/10/21. Full stop. Thereafter, case was fixed for further evidence of the plaintiff on 13/11/21. Full stop. In the meanwhile, certain IAs were filed on 7/12/2021, which were decided, and then case was afforded to the full stop.
प्रमोद नहीं बसंत है, वो हमने एप्लीकेशन पे बसंत.
ठीक है, चलिए. Prashant is busy in scenic duty, whereas Vasant Dwivedi is.
बसंत सैनिक ड्यूटी में, वो
अभी आप प्रशांत बोल रहे हैं.
नहीं, बसंत सैनिक ड्यूटी में है, और वो प्रमोद जो है वो विक्षिप्तता का उसके संबंध में हमने
Submitted that Vasant was in scenic duty and Pramod was. विक्षिप्त का मतलब क्या होगा? mentally retarded. Court recorded a finding that evidence of Pramod was recorded. Reason was given, no medical certificate was given in support of the application. Full stop. Even before this, even in this miscellaneous petition, when learned counsel for the petitioner is asked to show from the medical certificate about the medical health of the witness, then he submits that he has not produced any medical certificate along with the record of this miscellaneous petition. Next para. Taking these facts into consideration and the number of opportunities which have been given to the plaintiffs to lead evidence, decision of the trial court to close the evidence of the plaintiff cannot be faulted with. Full stop. Plaintiff cannot be allowed to prolong litigation as per his sweet will and desire. Next para. To that extent, decision of the learned court below is fully justified and does not call for any interference. Therefore, first prayer to permit an opportunity to the plaintiffs to lead further evidence is rejected. Next para. However, looking to the fact that issues were framed, some evidence was brought on record by the plaintiffs, trial court was obliged to ask the defendants as to whether they were interested in giving any evidence or not, and after recording their evidence or recording refusal, as the case may be, trial court should have decided the issues on the basis of the available evidence and should not have closed the case for want of evidence. Full stop. To that extent, impugned order is arbitrary and illegal and deserves to be set aside and is set aside. Matter is remitted to the trial court to afford an opportunity to the defendants to the suit to lead evidence if they so desire, and then decide the issues framed on the basis of the available evidence led by the plaintiff, already led by the plaintiff, and decide the suit on its own merits. Let this exercise be completed within 90 days of receipt of certified copy of the order. In our terms, petition is disposed of.
Highly placed.